So we've done the analysis for our cab driver problem, the one that we used Cohen versus Petty as our legal authority for. So now let's take a look at a sample memo. Let's see how this would look if we write out our analysis. But before we do that, please pause this video and read the memo once for yourself if you haven't already. So please read over this memo, the sample memo, and then return to the video after you've done that. So go ahead and pause the video right now. Okay, just as we did with the sample memo for our 3-star EcoCar problem, we're going to start with our issue. We're starting with our issue because we're still following the IRAC form. Under Washington, D.C. law, is defendant Matt Keegan liable for plaintiff Amy Marino's injuries under a theory of negligence when he suddenly lost control of his car and crashed into a tree during a narcoleptic episode, but he has successfully controlled his narcolepsy with medication for the past several years, and his last episode was over 3 years ago. So just as before, when we write out our issue question or issue statement, we want to pose it in terms of the relevant law and the relevant facts. Right? It happened during a narcoleptic episode. He has controlled his narcolepsy with medication for the past several years. His last episode was over 3 years ago. Right? So far, it's pretty much the same thing as what we've done before. All right, after the issue in IRAC comes the rule. So that's what this paragraph is right here. It's our rule for our analysis. In Washington, D.C., a driver who is suddenly stricken by an illness that renders it impossible for him to control the car, and which he had no reason to anticipate would occur while driving, is not chargeable with negligence. This rule just comes from Cohen versus Petty. We discussed that during orientation week. And so this is our rule. Now, we didn't know this law before we read it in Cohen versus Petty. So that's why we have to give a citation to the authority for the reader to let the reader know where we got this from. And after the rule, we can move on to our analysis. But remember, when we're IRACing with cases, it's not enough just to give the plain rule. We also have to, if the rule comes from a case, identify a few other things. We have to identify the holding of the legal authority that the rule comes from. That's just the conclusion that the court reached. We have to identify the relevant facts that led the court to that holding. And we have to identify the reasoning, why the court felt that those particular facts should lead to the conclusion, should lead to its holding. So let's do that now. If you look through this sample memo, we can see that the holding is stated right after we give the rule. This rule of law comes from Cohen versus Petty, in which the Court of Appeals of the District of Columbia held that a defendant whose passengers were injured in a car crash caused by the defendant's sudden fainting was not chargeable with negligence when certain facts were true. So this was the holding, right? The court reached this conclusion in Cohen versus Petty. And when we're IRACing with cases, we need to identify this to help explain our rule. We also need to identify the specific facts, and that's what comes after this when. He had never fainted before and was in good health. Now again, we know these facts because we read them in Cohen versus Petty. So we have to cite to the case. We have to give the citation to the specific page in the case, in fact, where we found these particular facts. This, well, all of this, I guess. All of this is laying out the specific facts that led the court in Cohen versus Petty to its holding. And finally, we have to identify the reasoning. The court reasoned that under those facts, the defendant did not know and had no reason to think he might become ill while driving. And because that's the case, he should therefore not be held responsible for his plaintiff's injuries. And again, this reasoning comes from the case of Cohen versus Petty. It's not just something we know off the top of our heads. And so we have to give the citation where we found this reasoning. This is the court's reasoning. This is why the court in Cohen versus Petty decided that these particular facts should lead to the conclusion that it did. All right, so now that we've done that, we have fully explained the rule. And now we can move on to our analysis. The analysis comes in this next paragraph. The analysis, or the application if you prefer. All right? In our analysis, what we're doing is identifying the arguments of both sides. And the way that we do that in analogical reasoning is to identify how our case is similar or different from the cited authority, from Cohen versus Petty. So that's what this sample memo does. Right? Defendant Keegan points out that, like the defendant in Cohen versus Petty, he was in good health at the time of the accident. And he had never fallen asleep before while driving. Okay, so these are the arguments that, or these are the facts rather, of our case that the defendant will point out. On the other hand, the plaintiff, Amy Marino, she's going to point out that, unlike in Cohen versus Petty, Keegan here has a history of narcolepsy. And so she's going to argue that because it's a little bit different in that way, he should have known that he might suffer a narcoleptic episode that day while he was driving. But just like a script, the arguments go back and forth. And so after this argument is made, Keegan can respond to that argument by pointing out that, hey, really, having a history of narcolepsy shouldn't matter here because he has controlled his narcolepsy for the past several years thanks to medication. And the last episode was over 3 years ago. And because of that, he really, despite his history of narcolepsy, he really had no reason to think he might suffer another episode on that day. So that's what we include in our analysis. We don't just give our conclusion and say, well, here's the rule, and we think that this is what the outcome would likely be in our case. Right? We have to show the reader what the arguments are for each side. And only then can we actually get to our conclusion. All right, so a few things to point out. Even when we're IRACing with cases, we're still following the IRAC structure. Issue, rule, analysis, conclusion. That doesn't change. Now, what goes into the rule is a little bit different. We had to identify the holding, the facts, and the reasoning of the cited case. But that's to explain what that rule is, and it's really to set up the analogical reasoning that we do in this analysis. But we're still following the IRAC structure. All right, another thing I want to point out is that we're still using specific facts. Specific facts, not just in our issue question, where we've already identified a certain specific facts, but also in our analysis. We're using the specific facts so that we can show the reader what the arguments are, and not just say, well, defendant Keegan is going to argue that this case is the same as Cohen versus Petty, period. We need to show how Keegan can argue that it's the same. It's because, specifically in this case, he's in good health, and that's similar to Cohen versus Petty. Also, specifically here, he has never before fallen asleep while driving, and that too is analogous to Cohen versus Petty. We do the same thing for both sides. Marino has to point out that Keegan has a history of narcolepsy. It's not enough just to say, Marino may argue that the present case is different, and so the outcome should be different. We have to show the reader how it's different, or at least how Marino thinks it's different. All right, so we're using the specific facts all the way through. And by doing that, we can really, in our analysis, highlight the best arguments of both sides. Now, the reason why we had to identify the holding, the facts, and the reasoning, what we're doing is, in the analysis, pointing out how the cases are similar or different. And then when we say, hey, if this court, the court for our case, if that court were to apply the reasoning, the same reasoning that the case in Cohen versus Petty used, what would the outcome be? And if we identify how the facts are similar, then we can argue that, well, the reasoning, if applied to similar facts, should reach the same outcome. The same reasoning applied to similar facts should reach the same outcome. But if the facts are different, if the cases are distinguishable, then applying the same reasoning would lead to a different result because the facts are distinguishable, because the cases are different, they're not analogous. So that's how analogical reasoning works. Now, one thing that's different about this sample memo from the sample memo we had for the 3-star eco car case is that we don't have any headings. And that's because in the last memo, we had separate elements for the statutory rule. And each one of those elements had an IRAC in and of itself. And so we gave headings to help the reader know, I'm now talking about this element. I'm going to give a full IRAC analysis for that element. And then now I'm moving on to the next element. But here we just have one rule. There's only one issue, so there's no need for a heading. So I do want to point that out. However, we still want to include transitions to help the reader along. Right? Here's an example of a transition. When we go from the rule, the sample memo starts the analysis by saying here. That cues the reader and lets the reader know that we're no longer talking about the rule and explaining where the rule comes from. We're now talking about how it applies to our case. We're now switching gears and talking about here, our case. Right? So that's something that helps the reader. Here's another transition phrase, maybe I should say, that helps the reader. Like the defendant in Cohen versus Petty, okay, already before I even get any further, I know that the reader is going to have a good sense that we're about to explain a case comparison. Like the defendant in Cohen versus Petty, certain facts, right? These facts are going to be similar or analogous, at least arguably, to Cohen versus Petty. All right? We do the opposite when we're talking about Marino's arguments. Marino may argue the present case is distinguishable because, unlike in Cohen versus Petty, right, another helpful transition for the reader to let the reader know what we're talking about. The goal of these, these transition phrases and roadmaps, the goal of them is to let the reader know at any point why he's reading what he's reading. So the reader, as he's going through your analysis, should have a very clear idea of why he's reading what you're reading. Otherwise, you're going to lose the reader. The reader's going to wonder, why do I have to read this? Why does this matter to my case? And so these transition phrases let the reader know what I'm about to write in this paragraph fits into the overall issue, to the overall problem in this way. Right? Thus is another commonly used transition phrase that can be very helpful. It's just one word, but it lets the reader know, now I'm about to give a conclusion to a particular argument. All right, so it lets the reader know we're now moving over into a conclusion. So again, analogical reasoning works because we don't just state the rule, we identify what the outcome was in that cited case, the specific facts that led to that outcome, and the court's reasoning for why those specific facts should lead to the outcome. Then each party can give his or her best argument for how our facts are similar to the facts in the other case. And then by showing that the facts are similar, can say, look, if you apply that same reasoning to our case, you'll get to the same outcome, just like we did in Cohen versus Petty. Or, alternatively, our facts are different. Here we have a history of narcolepsy. So he should have known. It's not that the defendant did not know. Here, he should have known. So he did have reason to think he might become ill while driving. So the outcome should be different. So this is an example of how analogical reasoning works in legal analysis.